Good afternoon, everyone. This is the Office of Consumer Credit Commissioner's stakeholder meeting to discuss the rules and model forms for property tax lenders. My name is Matt Nance, and I'm the OCCC's Deputy General Counsel. I'm joined by a couple members of the OCCC staff, including paralegal Ginger Harmon, who's acting as the meeting organizer, as well as our supervising examiner, Christy Graham. We're holding this meeting through an online webinar. We had intended to have an in-person meeting to discuss these rules and model forms. But like everyone, we're following developments with the coronavirus, and to help promote everyone's safety, we're holding the meeting only as a webinar. I'm sad that I can't see you in person, but we thought this would be a good way to be transparent in our rulemaking while also being safe. I want to thank everyone for joining the webinar. Getting input from stakeholders is a really important part of our rulemaking process, and these meetings help us make sure we produce the best rules possible. We're holding this meeting on GoToWebinar, and a lot of other workplaces are also holding meetings on GoToWebinar this week. So there may be some technical issues accessing the webinar or on our end and running it. If we have issues, we'd ask you to be patient with us. And if you're having issues on your end, I'd encourage you to keep trying because those issues may be resolved. Some of you might be listening on your phones, some may be watching on your computers, and some may be doing both. For those of you watching on your computer, there's a window where you can submit questions. If you have technical questions about using the webinar, you can type them in there and Ginger will try to answer those. If you have comments on the notice itself or the proposed rules or model forms, go ahead and type those in at any time and I'll be getting to those. If you're on a computer with a mic, there's a function that lets you raise your hand. So after I've presented my initial material, we'll let you make a comment verbally. So we're going to be addressing 3 issues in this meeting. First, I'll be discussing some proposed rule amendments on sworn documents and payoffs that the OCCC is considering. Second, I'll be discussing possible model forms and contracts for property tax loans. And third, I'll give an update on the advisory bulletin that the OCCC issued related to the coronavirus. And after I've initially discussed each of these issues, we'll have some time for questions and comments from stakeholders on all 3 issues. So the first issue we'll be discussing is rule amendments. These are rule amendments related to 2 issues that we've recently gotten questions about: recording the sworn document and payoffs for property tax loans with multiple properties. The amendments to the sworn document are pretty straightforward. After some amendments from the Texas legislature in 2013, the sworn document is no longer required to be recorded in the real property records. So our rule amendments would remove the words "after recording" on the model form of the sworn document. Property tax lenders would still be able to include this phrase if the sworn document will be recorded. The other rule changes would address payoffs of an individual property where a property tax loan is secured by multiple properties. In several situations, sections 32.06 and 32.065 of the tax code allow a lien holder or a mortgage servicer to pay off a transferred tax lien. We've gotten some complaints from banks about making sure that the bank can pay off the tax lien for an individual property where a property tax loan is secured by multiple properties. So these rule amendments are meant to make sure that there's a way to do that. A new rule at section 89.805 would explain the calculation method for an individual property in this situation based on finding an attributable percentage for the property being paid off. So in the meeting notice where we posted notice of this meeting, that's the document that says on top, notice of pre-comment draft and online webinar. If you look at the bottom of the first page, you'll see a calculation example using this method. In this example, parcels A and B make up 75% of the paid tax receipt amounts for the property tax loan. So you use 75% as the attributable percentage in arriving at a payoff amount for parcels A and B. The meeting notice lists the math that goes into arriving at a final payoff amount of $17,025. So as we said in the meeting notice, we're interested in knowing what stakeholders think are the costs and benefits of the proposed method, what methods property tax lenders are currently using, and any other method stakeholders might propose. If you think there's an issue with this method, I'd encourage you to propose changes so that we can try to arrive at a method that's going to work for everyone and enable payoffs in accordance with the tax code. Here's a proposed timeline for the rules. You can see that we're requesting informal comments by March 27th. We intend to propose the amendments at the Finance Commission's April 17th meeting. There will be an official comment period during the month of May. We present the rules for adoption at the Finance Commission's June meeting, and the rules will be effective in early July. This is a tentative timeline, and we're interested if you think a different timeline is appropriate. So those are the proposed rule amendments. Before we get to your questions and comments, I would like to keep going to our next two issues, and we'll take your questions and comments after that. So the next issue is model forms and contracts. Now, Section 32.06 of the tax code directs the Finance Commission to adopt some model forms by rule, like the sworn document and the pre-closing disclosure. But for a lot of other forms and contracts that property tax lenders use, there's no model form, and property tax lenders have to ensure that their form complies with the law. So some property tax lenders have told us they'd be interested in some model forms and contracts that could be used on a voluntary basis. As an initial step, we've prepared model forms for the right to cancel based on the forms in Regulation Z. Section 3206D-1 of the tax code says, a right of rescission described by 12 CFR section 226.23 applies to a transfer under this section of a tax lien owned and used by the property owner for personal, family, or household purposes. So we looked to the model forms for Regulation Z, 12 CFR Part 226, as a basis for this model form. So here are the questions that we're interested in hearing from stakeholders about. Again, this project is just at a very preliminary stage, and we'd like some more information before deciding whether or how to continue with it. We don't want to devote a lot of our staff's time, and your time for that matter, if no one's going to use these forms. So we're seeking feedback on how the forms would be used, whether market entrants would use them, how existing property tax lenders would use them, and whether existing property tax lenders would be willing to change their current forms. The next issue I wanted to address is the advisory bulletin we sent out earlier this week on the coronavirus. When we scheduled this meeting, I definitely didn't realize we were going to be discussing this. This is a really difficult time. I'm right there with you. I'm reading the news as it's coming out, and I wish I knew more about what's going to happen. So first, let me say, I am not a health expert, and for health-related guidelines and updates about the coronavirus, I'd really encourage you to go to the websites of the Centers for Disease Control and the Texas Department of State Health Services. The Texas Governor Office has also been posting updates, and your local authorities, your cities, counties, health authorities, taxing authorities, and courts most likely have websites that I'd encourage you to keep an eye on. What we've done is to issue a bulletin on property tax lending from unlicensed locations. It describes situations where we won't take an enforcement action when a licensee conducts activity from an unlicensed location. We do expect you to continue safeguarding consumer information and to keep documentation of what you're doing so that we can review it during the next examination. We are interested in feedback about whether you think we should revise the bulletin to address further issues that you're encountering in dealing with the coronavirus. This is a rapidly changing situation, and we may decide we need to revise the bulletin on our own. As we make any revisions, we'll post the revised bulletins to the page listed here. So with that, I've summarized our rule amendments, our model forms project, and our coronavirus bulletin. And now I'd like to see if there are comments or questions on these topics. Again, there are two ways to provide your feedback through this webinar. First, you can type your comment or question out and send it to us through the webinar's question feature, or if you're on a computer with a mic, there should be a function allowing you to raise your hand. And from Ginger, I'm seeing that we have a written question already. I'm going to go ahead and start reading that. These questions are from Jason Reedy. First question, will the rules on partial payoffs to lien holders apply retroactively to existing property tax loans? Second question, what benefit do you see for the consumer for allowing lien holders to disallow cross-collateralization, i.e. partial payoffs? Because it appears that the net effect to the consumer will be an increase in closing costs as consumers are now forced to do separate loans for each property. Okay, so I'll address Mr. Reedy's first question first, whether the rules would apply retroactively. So my current understanding is that the rules would not apply retroactively to loans entered before the date of the loan. But part of the problem we've been encountering is that the current statute already requires some mechanism for paying off a tax lien on a property where an existing lien holder has a lien or there's a mortgage servicer. So under current law, your property tax lenders are already obligated to allow that by some method, or at least that's how we understand the tax code. So when we've gotten these complaints from banks saying either the property tax lender isn't allowing us to pay off, or they're calculating that amount in a way that's overcharging me, we've had to go in and do some very intensive work analyzing the transaction, looking for overcharges, for failures in record keeping. And it's been a lot of intensive work by our consumer assistance department and in some cases our legal department. The hope with this was that it would create a simpler process going forward and a clearer calculation method in this situation in order to enable payoffs in accordance with the tax code. So that's the intent here. The rules themselves aren't retroactive, but we kind of have a problem already, or an issue with existing transactions, because the statute already requires some mechanism to allow those payoffs. I'm really interested in hearing feedback. You know, that's how I currently read the statute, but if I'm reading it incorrectly, or stakeholders think there's some other correct answer, we're interested in hearing about that. Okay, so that was the question about retroactive application. The second question is about cross-collateralization. And so this is a good opportunity for us to understand terms used in the industry. And maybe I don't understand this term the same way as the industry understands it, but my understanding of the term cross-collateralization was that referred to you have two separate loans, and the collateral for one loan is also the collateral for a second loan. And if that's what you mean by cross-collateralization, then that's not really what these rules are about. These rules are, you have one property tax loan securing multiple properties. So if I'd be interested to know in how stakeholders understand the term cross-collateralization in the context of property tax loans. But if, and I'd also be interested to know, Mr. Reedy seems to be interpreting the rule to disallow or allow lien holders to disallow cross-collateralization. I'm interested in knowing where or how is it that Mr. Reedy or any other stakeholders understand the rule to state that. Because again, you know, my understanding is that cross-collateralization is you have two separate loans. Collateral for one is collateral for another. This rule addresses the situation we've encountered in our complaints where you have one property tax loan secured by multiple properties and a lien holder wants to pay off one of those. Again, we've gotten complaints that is either not possible for them to do or that they're being overcharged. And the idea is to establish a method, a clear calculation method that will be an industry standard, so that this can be a standard method, and the parties can work this out without having to create a complaint that's going to take up a lot of staff and attorney time. So if anyone can follow up on the term cross-collateralization and how that's understood, that might be helpful, or if you'd like to put that in a written comment, that may be helpful as well. Okay, Ginger, do we have any other questions or written questions through the chat function, or any hands raised of folks who would like to speak? Okay, I'm showing we don't have any other questions at this time. If you're typing out a longer question, please feel free to type a quick message saying, I have a question, and we'll wait a little bit longer so that to give you some more time to type out your question. Okay, I'm gonna wait about one more, oh, we have a question coming in. Okay, this question is from Matt Longhofer. How would you like suggestions on changes to the model forms? So for suggested changes, I'd be happy to, if you have specific changes to the text, that would be helpful. The current model form is, again, based on section 3206 of the tax code and regulation Z. So what would be really helpful if you have a suggested change to it would be, show us your suggested language and then send some sort of explanation, maybe with a citation to regulation Z. But at a minimum, what it would be helpful to see is this specific suggested edit. As far as the format, we have the ability to open Microsoft Word documents, PDFs. It could be in the body of an email. There's not a specific format we need that in. We are also interested, like I said, in more general feedback about whether stakeholders think this is a good project and how they would use the model forms. Any other questions? Okay, have a follow-up from Mr. Reedy. Mr. Nance said that the rules wouldn't be retroactive, but yet that we still have to apply them to allow for a partial payoff, which makes it sound as if the rules are retroactive. So like I said, the rules are not retroactive, but the statute currently applies, and it's our understanding that the statute currently, when you have a lien holder or a mortgage servicer on existing property, the statute currently, and has for several years, said that in certain situations that lien holder or mortgage servicer can pay off the property. What I was saying is that that statutory requirement applies. But if stakeholders think that we're misunderstanding that requirement, let us know. It's also possible, this rule assumes that a property tax loan can be secured by multiple properties. The tax code only talks about a tax lien transfer on a property. So maybe, conceivably, it could be read to mean you can only have one property tax loan on a property at a time. That's not my current understanding of it, but maybe the right answer is that you can only have one property tax loan securing one property at a time. again, what we're trying to do is figure out a system that is consistent with the statute and enables the types of payoffs that are supposed to be authorized by the statute. And if folks have input on that, I'd welcome you to provide that input. Okay, any other questions? I do plan to allow for like 1 minute or so to see if anyone has any further questions or oh, okay. I'm sorry. I'm missing additional parts to Mr. Reedy's statement and questions. Okay, so continuing with Mr. Reedy, I'm not sure that Mr. Nance understands cross-collateralization. If a lien holder can obtain a partial payoff at any time, then the loan is not cross-collateralized. That is, one property is not serving as security for another. Okay, but nowhere in the statute does it grant a lien holder a right to pay off a property. It grants the lien holder the right to pay off the account. Okay, I'm not sure that the section 3206 uses the term account, but if you could send in some additional written comments on that, the rationale for how you think the payoff is really tied to the account, please let me know. I'm also really interested in what property tax lenders' current practices are if they have a property tax loan secured by multiple properties and a lender wants to come in and pay off just one or two of the properties. Is property tax lenders' current practice to say you just can't do that? Is it to say we'll let you do that under certain conditions? So we're really interested in knowing that as well. Okay, we have a question. Oh, I'm sorry. The statement about the account was okay. We may have an additional question. Just one moment. Okay, we do have a question from Peter Squire. Is your understanding that the 3-day right of rescission ends 3 days after the signing, or that the borrower can drop a cancellation notice at 11:59 p.m. of the 3rd day and then have the time it takes to get mailed to the lender as additional time that we have to wait on? So I was looking at Regulation Z, 226.23, I think it's D, and it talks about how if the consumer notifies by mail, the notice is considered given when mailed. So if you want to comply with 226.23A2, it seems like the notice is going to be considered given when mailed. So if there's a way to square that with mailing and placing the notice in the mail, I'd be interested to know. If you require delivery by the 3rd day, then that starts to seem like the consumer has to like get the notice and immediately drop it in the mail. So I'm interested in hearing people's feedback on that. Again, section 3206D-1 of the tax code says that a right of rescission under 12 CFR 226.23 applies. So that's the text we were looking at. So yeah, I'm interested in feedback if people have a different understanding of Regulation Z, or you know, whether the consumer has to turn around, get their notice, and immediately put it in the mail. in order to cancel. And remember that this forms project is a test. We're trying this out. We're seeing folks' initial impressions to see whether we're going to continue with this project. I kind of thought the notice of the right to cancel would be an easy one since there's already a model form. But again, feel free to provide your feedback on this. If you have a different understanding of Reg Z and suggested changes based on that understanding, feel free to let us know. Any other questions? Okay, I'm not seeing any new questions. I'm going to wait about 1 more minute in case anyone wants to submit a question or raise their hand to speak verbally. Again, if you have a longer question to type out, send a short message and let Ginger know. Oh, looks like we have a question. I'm standing by. Oh, okay. Never mind. I'll wait about 30 more seconds. Okay, I want to thank everyone for listening in on the webinar. Again, as always, rule updates are available on our website, and we'll also be posting audio of this meeting. We are accepting written pre-comments on these rules and forms until 5 p.m. next Friday, March 27th. Please email those to me at rule.comments@occc.texas.gov, which is our email address for rule comments. Thank you all for attending. Please be safe out there. Take care of yourselves, take care of each other, and we will see you next time. Thank you.